Dreaming of buying your first home? Before you sign any agreement or pay a single rupee, you need to know your rights under RERA, the Real Estate Regulatory Authority Act. In this video, Consumer Times breaks down everything a home buyer must know in 2025, from escrow protection to delay compensation, from mandatory transparency to how to file a complaint if your builder cheats you. RERA is not just a law, it is your shield. And in 2025, with the powerful RERA 2.0 updates, this shield has become stronger than ever. Builders now face higher penalties, stricter deadlines, and real accountability. Watch till the end to find out exactly what you can demand from your builder, and what steps to take if they fail you. Namaskar, and welcome back to Consumer Times, where we put power back in the hands of the consumer. I'm Dr. Arun Kumar, your host, and today we are tackling one of the most important topics for any Indian family: buying a home. It's the biggest investment of your life. But do you know what legal rights protect you when a builder delays your flat, changes the layout without permission, or disappears with your hard-earned money? That shield is called RERA, the Real Estate Regulatory Authority, and today, we are going to decode every right it gives you. The Real Estate Regulation and Development Act was enacted in 2016 and came into force in 2017. Before RERA, India's real estate sector was like the Wild West, unregulated, opaque, and heavily tilted in favor of builders. Buyers had almost no legal recourse when projects were delayed by years or when promised amenities simply vanished. RERA changed all of that. It created a mandatory registration system, state-level regulatory authorities, and a clear legal framework for disputes. In 2025, RERA 2.0 has made this framework even stronger with higher penalties, better technology, and faster grievance resolution. Your very first right as a buyer is simple but powerful. No builder can advertise, market, or sell a property without first registering it with the state RERA authority. Every registered project gets a unique RERA registration number. Before you pay even 1 rupee as a booking amount, you must verify this number on your state's official RERA portal. This gives you access to the project's layout plans, government approvals, promised completion date, and even the builder's track record. From April 2025, builders cannot even advertise pre-launch offers without a full compliance certificate. If a builder asks you to book without RERA registration, walk away. That project is operating illegally. One of the biggest scams in old-school real estate was fund diversion, builders collecting money from buyers in Project A and secretly using it for Project B or for personal expenses. RERA put a hard stop to this. Under the Act, builders must deposit 70% of all money collected from buyers into a dedicated escrow account. This money can only be used for that specific project's construction and land costs. In 2025, builders must upload quarterly statements of all escrow withdrawals for RERA to monitor. Your money cannot vanish into another project. This one rule alone has saved thousands of home buyers from financial ruin. Before RERA, builders used to charge you for the super built-up area, which included walls, corridors, lifts, and even the lobby. You were paying for space you could never use. RERA abolished this. All property pricing must now be based on carpet area, the actual usable floor space inside your flat. This is a massive win for buyers. A flat that used to be quoted at 1,200 square featuring super built up may actually have only 800 square featuring of carpet area. Under RERA, you pay for what you actually get. No more inflated numbers. No more misleading brochures. This is the right most home buyers need, and it is one of RERA's most powerful provisions. Under Section 18 of the RERA Act, if a builder fails to hand over possession by the agreed date, you have two choices. First, you can demand a full refund of your entire investment with interest. Second, you can choose to stay in the project and receive monthly interest compensation for every month of delay. Under RERA 2.0, the compensation rates have been significantly increased, making it genuinely costly for builders to miss deadlines. In Karnataka, KRERA recently ordered a builder to pay over 1 crore rupees as delayed interest to a single buyer. The message is clear: delays have consequences. Getting the keys to your flat is not the end of RERA's protection, it's just the beginning of another layer. Under RERA, developers are liable for any structural defects, quality issues, or poor workmanship reported by buyers for up to 5 years after possession. And here's the best part: they must fix it free of cost. Whether it is seepage, faulty wiring, cracked walls, or broken fixtures that were part of the original promise, the builder has no choice but to repair it. This 5-year defect liability clause has forced builders to genuinely invest in quality construction. RERA requires builders to publicly disclose every detail of the project: land titles, approvals, layout plans, financial status, and construction progress. You can verify all of this on the state RERA portal before you invest. More importantly, builders cannot make any changes to the approved plan, amenities, or layout without the written consent of at least 2/3 of the buyers. So if a builder promised you a swimming pool, a clubhouse, and a green park, they cannot quietly shrink or remove these without your consent. Any advertisement or promise that is officially filed with RERA becomes a legal commitment. If a builder violates any of these rights, you can file a complaint directly with your state RERA authority. The process is now completely digital. Most states allow online complaint filing with document uploads and real-time case tracking. You can even attend hearings virtually. RERA targets resolution of complaints within 60 days. If the builder still refuses to comply after a RERA order, states like Karnataka and Rajasthan can seize the builder's property and sell it to pay your dues. Penalties for violations can go up to 10% of the total project cost. Builders who mislead buyers or delay repeatedly can be permanently blacklisted. So there you have it, your complete RERA toolkit as a home buyer in 2025. Always verify the RERA registration number before booking. Check the escrow account compliance. Demand pricing in carpet area. Know your right to compensation for delays. Insist on quality post-possession. And never hesitate to file a complaint if a builder cheats you. At Consumer Times, we believe an informed buyer is an empowered buyer. If you found this video helpful, please give it a thumbs up and share it with anyone who is planning to buy a home. Subscribe to Consumer Times so you never miss your rights. See you in the next one.